Hello, good morning, everyone. My name is Omar Dominguez, and I am the Manager of Corporate Engagement and Advocacy at SHARE. I also lead Canada Engagement Canada's Secretariat Research and Engagement Program. I want to offer a warm welcome and a heartfelt thank you for joining us today for this webinar of Climate Engagement Canada participants and responsible investors. I am joining you today from the traditional unceded lands of the Musqueam, the Squamish, and the Tsleil-Waututh people in the region currently known as Vancouver. I also acknowledge the enduring presence of First Nations, Métis, and Inuit people in this country. And so as we gather today to learn about these important issues, I would like to pay my respects to the elders of these nations for stewarding the land, water, and life of this region for thousands of years. I also invite you to let us know the region and the traditional territories where you're joining us from. Climate Engagement Canada is a collaborative investment network mobilizing Canada's financial community towards a net zero economy. Currently, CEC is comprised of 36 investors, which have managed over 4 trillion of assets under management. CEC focuses its engagement efforts on 40 high GHG emitting companies listed in the Toronto Stock Exchange. It seeks to maximize the impact and decrease the emissions as we help Canada meet its commitments to the Paris Agreement and build a low carbon future together. Today's webinar explores the relationship between CEC or corporate issues and the regulatory and policy landscape that contextualizes our work. Indeed, the ideal policy in an ideal policy environment, it is arguable that some aspects of our work and stewardship and engagement on climate change would become redundant. And furthermore, when we have a clear understanding of the state of play with climate policy and the state and sub-state level, we can do things better. First, we could help ensure that we're working in tandem and as we seek progress with issuers. And second, that this understanding allows us to use our voice and investor perspective to support good policy and discourage bad policy. So after just this brief introduction, it's now my pleasure to turn it over to Sonia Lee Trottier from our valued educational partner, the Canadian Climate Law Institute, to tell us more about their important work at the intersection of climate change and Canadian regulations. Thank you very much for everybody, your ongoing commitment.
Thank you, Omar. I'd like to start by saying that I'm joining from the traditional and unceded Indigenous land of the Kanakahage Nation, currently known as Montreal. My name is Sonia Lee, and I'm the Director of the Canada Climate Law Initiative. CCLI provides businesses and regulator climate governance guidance so they can make informed decisions as we move toward a net zero economy. We work with boards of directors and trustees to ensure they understand their legal duties with respect to climate. Today, I'm very pleased to introduce you to our speaker, Dr. Janis Sarra, who's Professor of Law at UBC and Principal Co-Investigator at CCLI. Janis, over to you.
Thank you. Thank you very much, Omar and Sonia Lee, and thank you very much for all attending. It seemed like a good time. We're near the year end and everybody's just on the cusp of starting to celebrate festive season to try to really figure out where we're at in terms of the regulatory landscape and climate related disclosures. I put an image up of puzzle pieces because if you're a busy person in your life and investment portfolio, sometimes it's hard to keep track of exactly what goes on or how the pieces are fitting together. And so the aim of this sort of very brief snapshot today is to sort of tell you the current state of play of that elaborate puzzle. There are parts of the slide presentation that are text heavy, and I'm definitely not reading them. But Sonia Lee has kindly agreed to make it available to anybody on this call that would like to have a look more carefully at the text as we go along. So on the good news side, I think it's fair to say, okay, good, sorry, it's working. So on the good news side, I actually think there is truly some convergence now towards making a commitment to a global baseline of sustainability disclosure. And if you had asked me that even 2 or 3 years ago, I would have said we're a long way off from it. And I think that's encouraging. And in that vein, I've been going to talk about particularly the Canada developments. So probably everybody knows that the Canadian Securities Administrators have been engaged with this issue for a few years now. They had a staff notice in 2019, which really advised us all that climate change is a mainstream business risk and that boilerplate disclosure was no longer acceptable. Then about 14 months ago, they issued the proposed National Instrument 51107, Disclosure of Climate-Related Matters. So that's been sitting there out in the public domain for 14 months now. And of course, they received 131 submissions from many of people who are probably on this call and others. Almost immediately, and you can see there were some important TCFD aligned, so Task Force on Climate-Related Financial Disclosures, aligned disclosure requirements that were in that draft instrument, such as the fact that governance and risk management of climate risks must be reported regardless of a materiality threshold, which of course is a shift from current securities regulation. And then disclosures on strategy targets and metrics only if material. What happened though was, and that proposed national instrument at the time said if it was in place by December of this year, which is not going to happen, then it would kick into force 2 years later, and with a scaled thing for smaller issuers. Almost immediately, the draft national instrument was overtaken by the Securities and Exchange Commission draft rule in the United States. And then closely on the heels of that, the new International Sustainability Standards Board also issued, even as the board was being announced, some sort of reflective papers on standards, which really made our national instrument look like it was so lagging behind. So, so after a lot of deliberation, the securities administrators a year later, in October of this year, said that it's still reviewing the ISSB developments and the SEC proposed rule. But that in fact, their commitment is still there. And just to quote from October, Stan Magidson, who is the chair of the Canadian Securities Administrators, but also the CEO of the Alberta Securities Commission, is that CSA supports a comprehensive global baseline of sustainability disclosures as a priority. So that is a shift in the CSA's language, which I'm really happy to see. And it says to me that while they take some time to build consensus among the securities regulators in this country, that they are trying to work towards something that doesn't leave Canada out in the cold vis-a-vis all of the other developments that have overtaken this year based, on the national instrument. But the other thing you might not have caught in this is some new noises from the Canadian Securities Administrators, or CSA, about greenwashing and about the fact that they're not waiting for a national instrument to start to signal the importance that there aren't misrepresentations in disclosures. So that's good news for investors who are trying to manage portfolio companies, trying to figure out what's valid or not. So some of the cautionary notes just this past month are that audit committees and external auditors need to be really diligent in fulfilling their responsibilities to ensure that the information is timely, accurate, and supports investment decisions. But they also issued in their continuous disclosure review, so it's a 2-year review of continuous disclosure, a new section called Overly Promotional Disclosure, brackets greenwashing. And this report, which has a lot of different kinds of enforcement activities, so you may not have had it drawn to your attention, really talks about how rapidly climate ESG and sustainability disclosure has grown, that it refers to a wide variety of factors such as just transition, diversity, inclusion, biodiversity, etc. And that the breadth of the term means that they can be very misleading if there's not more specific disclosure. The CSA then has found in its enforcement activities that there's an increase in issuers making potentially misleading and unsubstantiated statements, and that it's starting to identify greenwashing and sending disclosures back to companies, back to issuers for either revision. They haven't started, to my knowledge, and I'm pretty up to date on this, actually enforcing in a way that would be public and a sanction, but they're definitely now making noises and asking for more clarification. So the bottom line for this, this new notice in November is that when describing current and proposed ESG-related activities, including climate, issuers should avoid misleading or promotional language, and that all public disclosures, whether they're required or voluntary, must be factual and balanced. So even if they don't move as quickly as what some of us would like on National Instrument 51107, the clear message is there. The other thing really interesting about this document, which I do want to spend a minute for, is they give an example. And basically what that example is, they say a company has said it plans to be carbon neutral by 2023. That they have a strategic relationship with high quality partners attentive to environmental stewardship, and they set aggressive emissions reduction targets, and the company is a global leader in environmental solutions. So this is a real example that CSA has used. And here's their analysis. Their analysis says the issuer made an unsubstantiated claim stating it would be carbon neutral in the very near term. And basically it's misleading disclosure unless it can be supported by facts and corporate activities. It also said that this kind of statement is typically forward-looking information, or FLI, and you can't disclose under current law FLI unless you have a reasonable basis for doing so. So that any disclosure regarding material forward-looking information has to include all of the material risk factors that could cause actual results to differ materially, state the material factors or assumptions used to develop it, and describe policies for updating it. And so basically, and then the other thing about this example was that there was promotional language about partnerships of this other company being high quality and aggressive emissions, and that is actually also misleading. So it's an interesting example to go and have a look at, because it's pretty clear that boilerplate, they're going beyond boilerplate now, and they're going to start to enforce claims that are not backed up by facts and by detail. That's good news for investors. So just to also briefly look at the rest of the landscape here, we also now have Office of the Superintendent of Financial Institutions, or OSPI, has issued its guideline B15 on climate risk management. This is a guideline that is expected to be finalized early in 2023. It will apply to federally regulated financial institutions. There are over 300 of them, banks and insurance companies. They conducted a consultation period, and that period is over. And basically, it's the first sign, I think, we see of real leadership in terms of regulation within Canada. It's a comprehensive sort of guideline on governance, risk management, strategy, metrics, and targets. But more importantly, I think, is not only is it Task Force on Climate-Related Disclosures aligned, but have detailed guidance on what these requirements look like for purposes of financial institutions. And OSPI's mandate, of course, is to protect the safety and soundness of financial institutions and our financial system. So they're requiring certain things embedded in the internal capital assessments, risk appetite frameworks, and stress testing that they already do as they protect the financial system, but now they're asking for scenario testing and other stress testing by financial institutions to make sure the kinds of decisions that they're making comply with their own obligations on capital and adequacy and liquidity. But more importantly, there'll be a lot more information, particularly for the banks, but the large insurance companies too, on the nature of finance transactions and the nature of both the risks and opportunities, both up and down the value chain. The guideline is requiring transition plans in the path to a low carbon economy. So the current draft, which hasn't been finalized, talks about low carbon economy, not net zero, but a number of their submissions did ask them to change that to net zero. So we all need to just stay tuned if that shifts. And there's no question that the larger financial institutions are going to have to report their scope 1, 2, and 3 emissions, but there's a scale down approach, not unlike the UK governments, in the sense that it will be an entire all sizes fit approach eventually, but they're starting with the largest financial institutions. And as you probably know, the 6 big banks control 90% of the banking assets in the country. So that is really a very significant change. There's also the Sustainable Finance Action Council, or SFAC, and it's got a proposed Canadian transition taxonomy. You may recall that the Canadian Standards Association had an ill-fated attempt for a couple of years, didn't get anywhere. The government appointed SFAC to try and come back to it with a green and transition taxonomy to the federal government. If you go on their website, besides their announcement, you don't hear much. But I do know that it's the taxonomy, or the pathway to the taxonomy, has now been recommended to the federal government. It's expected, excuse me, it's expected that that taxonomy is going to be made public in the next week or two. So you should keep an eye open for that. But basically, it proposes a two-phased approach. The first is to publish a short form taxonomy, which covers priority sectors and activities by mid next year. And so it's really laying the foundation for long-term taxonomy, including sort of how it's going to be accomplished. It will include things like a taxonomy council, expert advices, and sort of broader NGO and citizen participation. I think the short form taxonomy will really tackle the green part of the taxonomy, where things are easy to identify. And then phase 2 is to really fully implement the taxonomy initiative and publish a substantially more complete taxonomy by the end of 2025. So some of us might think that's a long time frame, but we're at least making progress forward, and I think that that's important. The taxonomy has really basically 3 criteria to say that any product or service is eligible to be issued as either green or transition. The company has to have company level net zero target setting, so that's huge. Also transition planning, that's also huge, I think, in terms of requirements, and then effective climate disclosure. Then there's going to have to be an evaluation of whatever the thing is that wants the taxonomy designation against the framework criteria to determine whether it's green or transition. And then there'll be a new no significant harm to other ESG objectives threshold. And I think some of the hard work will be looking at or discerning for the transition part of the taxonomy, what do no significant harm means. We have lots of models, though, out of the European Union, the United Kingdom, Singapore, Japan, etc., for that to happen. The other thing that SFAC is doing, which I've just flagged without talking about, is it's commenced something called the Net Zero Capital Allocation Initiative, and it's really trying to put together how to best allocate capital in its transition to net zero, and to give the government some advice. And it's comprised of investor organizations and financial institutions in that initiative. Just turning briefly to the international developments, of course, we have the International Financial Reporting Standards, International Sustainable Standards Board, or IFRS, ISSB. They issued 2 exposure drafts, one on climate-related disclosures, that's F2, and one on general requirements for disclosure of sustainability-related financial information. And so here we have an organization, many Canadians report to IFRS standards. All of the what are called publicly accountable organizations, banks, insurance companies, etc., report to IFRS. And so this will be a significant change. And as probably you know, one of the 2 offices of IFRS, ISSB, is located in Montreal. So there are, there's been a commitment by the Canadian government, by our accounting and actuarial associations, to say this is an important project to get at that global common language standard. And both, there's a lot of speculation, but the latest is really that there's a deep expectation that probably at least the climate-related one will be in place, in force, or in place and finalized by Q1 of 2023. So I'm just going to spend a minute talking about the climate one, not the sustainability disclosure one. I want to make sure we're leaving lots of time for questions at the end. So the objective is really to require an entity. An entity, of course, can be a company, a financial institution, anybody who's reporting to IFRS, to disclose information about its exposure to significant climate-related risks and opportunities. that enable users of the entity's general purpose financial reporting to assess a number of things: the effects of significant transition and physical risks and opportunities to enterprise value, to understand how the entity is using resources, activities, outputs, how it's responding strategically to manage the risks, and then be able to identify the entity's ability to adapt its business planning model operations. So IFRS is aimed at something bigger than securities law in the sense it's more than investors, it's any users of general purpose financial accounting. So that could be regulators that are using it, it could be civil society organizations, it could be beneficiaries of or direct beneficiaries of fiduciary organizations. And so it's aimed at giving those users much more information. It's also structured roughly, not entirely, but roughly around the TCFD pillars. So on governance, for example, you can see here, and I won't go through everything, but it's really who's the governance body, committees or board, et cetera, with oversight and management of the risks and opportunities. And then information about how that is then that oversight is being communicated in terms of the management of it. So, is the board, does it have appropriate skills and competencies in place to manage, to oversee this or to manage this? How often are they assessing it? How is it embedded in major transactions? How is it embedded in assessment of trade-offs and areas of sensitivity? How is the board or what other governance body overseeing setting of targets and measuring the progress? And then how is that all measured by remuneration for senior executives? And then on the strategy part, here again, I'm not going to read the whole thing, but really it's saying you have to embed strategy and you have to be prepared to disclose strategy in terms of how significant climate-related risks and opportunities that it reasonably expects the entity, in other words, the issuer, the company, the financial institution, could affect business model, the value chain, cash flows, etc. And what the opportunities are, how the strategic planning fits into that, and anticipated effects over a whole range of timelines, short or medium and long term. And then really a key part, I think, is sort of an analysis of resilience. In other words, what's the implications of the strategy and how resilient is the strategy to unanticipated changes? We know climate change is very certain, but of course the speed and the parameter of the changes is less certain, but definitely urgent. And so this is giving reporters a time frame over which they can report. Risk management, I couldn't resist this image of moving parts because that's how I view risk management. It's a lot of moving parts right now, but the reality is, I think, for what IFRS ISSB S2 is doing is saying, how are you embedding risk management of climate-related risks and opportunities into the rest of risk management? And then how are you prioritizing it in relation to others, including the risk assessment tools being used? It also embeds some safeguards in terms of making sure you're disclosing if you're changing your processes for assessing risk management so that you can't just move the goalpost and report, in other words, year-over-year comparison, which will in turn give us also company comparison. And then there's definitely targets and metrics. I think this is one that's being hotly discussed in the ISSB meetings. If you haven't gone online, they are very transparent about their discussion papers and about the results of their discussions. But at this point, the targets are very much part of it. And at this point, they've retained requirements in terms of scope 1, 2, and 3 emissions, in terms of both sort of absolute emissions and intensity. And then obviously, if they can't report scope 3 in particular, and we know this can be a challenge, then it's basically the reasons for not. Now, one of the things you'll find really interesting if you're not tracking this closely is that in November, just last week, I guess, it gave a summary of all of its decisions to date. So unlike many of our processes where consultation ends and then this black box is sitting there while all of us try to figure out what's going on, is that the ISSB is, as they're making decisions or as they're making what they call tentative decisions, they're actually posting it. So there's a really handy summary November 28th on their website of all the decisions they've made so far. And these are called tentative decisions, but as I understand from the ISSB, they're fairly determined. It's just that they don't want to call them final decisions because they get further in the process about a standard and realize they have to adjust one that they've already deliberated. So I'm just put one example up here. I resisted the temptation to give you 10 slides on this, but this is scalability. I thought was an important one for this particular audience, and that is, identifying mechanisms to enable disclosure requirements to be scalable when relevant. In other words, size of entity, maturity, whether it's research and development, whether it's the criteria need to have some proportionality and some scalability. And so that's a decision that has been made now and is part of this list of decisions, which is really important for Canada, given that we have such a huge venture issuer and smaller cap company market. So my bottom line for this part is that the convergence commitment is growing, which I find encouraging. And I'll give you a couple of quick examples. ISSB is working with the European Commission and EFRAG towards a shared objective. So you'll recall the European Commission adopted a legislative proposal for a corporate sustainability reporting directive, or CSRD, that requires a new double materiality perspective in compliance with reporting sustainability. Now, the ISSB draft doesn't mention double materiality at all, so there'll have to be some real discussions. But now EFRAG, which is the technical reporting group of the European Commission, as of November 22nd, actually tabled its first draft of standards under the ESRS, including one on climate change. So now that we see how public that is, the ISSB and the European Commission have committed to work together to get as much convergence as possible. The ISSB is also working really closely with the International Organization of Securities Regulatory Organizations, commissions, so to see if they can align, again, securities law disclosures with accounting standards. And CDP, which, the climate disclosure standards, have now said they will actually incorporate the IFRS standards in their requirements. So I think we see for the first time that a greater appreciation in Canada and across the globe that to have many taxonomies and many different standards will mean that opportunities for investors will be slowed down and the transparency and accountability will be problematic. So you might ask, well, where does the new Canadian Sustainability Standards Board fit in? And I certainly wouldn't pretend to speak for it, but I did watch some videos and I did try to read from their website exactly where they're going to fit in. It's of course expected to be operational by April 2023. And what it's suggesting is that it will be reviewing the ISSB standards and advising the board in respect of its application in Canada, but that it supports this idea of a global passport in financial reporting, particularly for multinational corporations. It doesn't say anything particularly about the domestic ones. It says also that accounting standards have diverse entities beyond publicly traded issuers. I've already talked about that. And their goal is to extend and adopt standards for other entities, but that it will work in lockstep with the ISSB. So I think because they're just picking their chair now and recruiting their board, we'll have to stand by and see what their contribution is. A couple of other things. I am keeping an eye on the time, and I think I have about another 10 minutes, so I'm going to take it. The Canadian Netzero Emissions Accountability Act, you might wonder why it's even in these slides, because of course it's binding the federal government to set 5-year national emissions targets and develop science-based emissions reduction plans. And so it's got its commitment now, and it's very government focused. But it's important for investors as well, because what it's really doing is creating tremendous opportunities for partnership, for joint public-private financing, for taking advantage of opportunities to really see if we can do a whole economy shift to net zero emissions. And to just give you one example, the 2030 emissions reduction plan looks like it has money being thrown at it, but what's important about it is it's really trying to be very targeted in terms of growing the economy at the same time as trying to reduce emissions. So a lot to, electric vehicle charging infrastructure, a regulated standard, a new net zero buildings plan for the country, other initiatives that are really counting on private capital to be partnering with some federal incentives to actually transition the economy. And when you think about, well, what is this written disclosures? Because there has to be a certain amount of transparency about all of this that investors will be able to take advantage of, or at least track their portfolio companies to see if they are taking advantage of those opportunities. A quick word on the US, very quick. Of course, their proposed rule on climate-related disclosure came out in March 2020. It was much more comprehensive than the Canadian proposed national instrument in terms of all sorts of disclosures, including metrics and targets, etc. The Canada Climate Law Initiative actually did a comparative study of what the SEC is proposing, what Canada's securities regulators are proposing, and what the ISSB is proposing, and you'll find on our knowledge website in great detail. The scuttlebutt is, if one believes that it's now the midterms are over, they're going to move quite rapidly to finalize the rule. But even as of this morning, there's no actual announcement about when that might be. But they haven't just rested their laurels on climate-related disclosure. So they've also proposed a rule on ESG disclosure practices that it's important to be aware of, really aimed at, again, accuracy, reliability, and comparability of various ESG management, asset management practices. And so that rule is, again, it's still a proposed rule, and it's really targeting both ESG-focused funds in terms of how they have to disclose both quantitative and qualitative terms, but also tackles ESG integration funds and how that is. And rather than sit on just the proposed rule, they've actually started quite a bit of enforcement on ESG. So just to give you a couple of examples, they went after BNY Mellon Investment Advisor for misstatements and omissions about ESG considerations in terms of making investment decisions. And that was a 1.5 million penalty to the SEC as settlement. They also went after another case, Trouble Milton, which was filed in the District of New York, Southern District of New York. And this is a company that, you know, its primary goal is manufacturing trucks on alternative fuels with no or low zero emissions. But basically, the primary spokesperson was really misrepresenting their capacity. And so in December of last year, the corporation agreed to pay $125 million to settle the charges that it defrauded investors and all sorts of representations. And as you can see by the first example, Deutsche Bank, which also the SEC has investigated, but BaFin, which is the German Financial Services Regulatory Authority, actually brought the criminal police in and searched the offices of Deutsche Bank's asset management firm DWS. And again, overstating information on ESG requirements. So again, you can see the trend here. And the last one I'll show you is the most recent one from about 2 weeks ago, where the SEC charged Goldman Sachs asset manager. And without reading all of this, basically, there were two things. First of all, in some cases, they were representing products as ESG without having any written policies and procedures. And in another case, in fact, they had the policies and procedures, but they were making the investments, or they were making the decisions, and then they were filling out the ESG questionnaires after the securities were already selected for inclusion, which is really, of course, problematic. And of course, it's a throwback to how the mortgages were being rewritten after sale in the subprime mortgage debacle, in 2008. So in this case, Goldman Sachs Asset Management had to pay $4 million in penalty. And I think it's just a sign of things to come, that rather than wait for the perfection of the rules, that under existing law, if it's material and misrepresenting it, enforcement will happen. Last couple of points I want to make is that the Competition Bureau of Canada, which of course, if most of us are working in financial services law or securities law or corporate law, don't think about so often. But in fact, the Competition Bureau has as part of its mandate to prevent deceptive marketing practices. And it defines greenwashing as making vague or misleading environmental claims of environmentally benefit products and processes. And basically, they're prepared to increasingly scrutinize greenwashing in advertising campaigns. And I mention this because if you look at their annual report, they have a identified financial services as one of the areas that they're going to investigate consumer complaints about misrepresentation. So why is that important? I mean, it seems very curious, but in fact, they do have the mandate. I went back and looked carefully at the statute a couple of months ago to see whether they do have that jurisdiction, which is quite different than securities law misrepresentations. And to just give you a comparative example out of the UK, this is a case where HSBC was sanctioned for a couple of billboard ads, which you can kind of see in the images. The one in the bottom is, of course, the growth rings of trees, and the one which is a little harder to see is the ocean. And basically, in this case, which was in October of this year, the UK advertising standards ruled that the bank could no longer run the ads because although what they said in the ads was true in the terms of some resources being dedicated to planting trees and to reducing warming, they were misrepresenting the fact they were actually heavily invested in maintaining and increasing fossil fuel emissions. And so the fact they run the ads was misrepresentation because it led consumers to believe they were making a meaningful contribution to decarbonization when they weren't. And so I think what's interesting, of course, without commenting on this case, there's now almost exactly the same case in front of our Competition Bureau by a number of Indigenous complainants about one of our banks, saying that again the advertising is misread. It's ongoing, so I'm not going to comment on it. But I will say, if one takes the sum of what the UK approach is and what our securities regulators said in that example I gave you, then all of us, investors, issuers, and others, need to be really thoughtful about what we're claiming we're doing in our disclosures going forward. So that's it. I'm going to shift to questions. I think, yes, we have some time for questions, and hopefully that was some of assistance. And I'm going to stop share, and then I think I can probably see questions.
Thank you, Janis. We received 2 questions so far, and if you have more questions, you can write them in the Q&A box. So the first one is, what are the key implications for companies as these disclosure requirements come into place? What can they do now to prepare? Example, securing resources responsible for ESG disclosure, seeking assurance for ESG information.
So that's a really good question. I think that the first is really to kind of keep track of the standards as they're developing. And as I said, I think I can see this convergence, which is going to make it quite easy. So if you'd asked me 2 years ago, I would have said, oh, if you're a financial institution, you're going to have the Canadian securities regulators and the IFRS, and then financial services regulation, and it would have been a bit of a nightmare. But what we see is a convergence. Having said that, of course, some resources may be required, but I think there's a lot of concern about smaller investors and smaller issuers about whether they have sufficient resources. And increasingly, organizations are creating tools to assist, whether it's the greenhouse gas protocol, whether it's the principles for accounting standards, there are more and more tools that are freely available to start to be able to manage that. For venture issuers, the TMX group, for example, has developed a template for how you start to record and think about it. And it's not requiring these templates, but it's really giving a free service to say, here's ways you can prepare. Certainly the Canada Climate Law Initiative and Climate Engagement Canada are trying to offer some resources and tools to be preparatory to this. CCLI makes board presentations. We have over 60 lawyers, accountants, CEOs, et cetera, that will come and talk to boards, whether they're pension boards or whether they're companies, to just say, here's the lay of the land and here's something you could do. But for me, the bottom line is it's important to be really clear, especially ESG, even more than climate, of what you're trying to accomplish, and not to sort of take on everything in ESG all at once, because inevitably you're bound to run into trouble. So, on social, is it that you care about a just transition? Is it that you care about Indigenous reconciliation? It's not that these issues aren't really important, but I think where companies get into trouble is that they represent that they're doing all things for all constituencies on ESG. And it's highly problematic because actually no one yet can do that I know of. And the organizations that are trying to do it are very large organizations. So to be very key about, what's the industry, what's most important to that industry in terms of ESG factors. I'd argue that climate is relevant to all of them, all sectors now, but for the other ones to be discerning about what that is and prepare in that way and be prepared to say, if this is a priority and we're disclosing this as the action, what are those factual underpinnings, as the CSA example shows us about that. And I think that's the best way to prepare. And there's no question our regulators are going to give a bit of space as people tool up, I think. But now is the time to be doing that preparatory work and at least having the board as knowledgeable as possible so that when rules are finalized, they actually know what's expected of them.
Thank you, Janis. We have a second question, which is one of the big challenges has been that when companies do disclose climate-related risk, they appear in separate sustainability TCFD reports and are not integrated with financial statement. This can lead to inconsistencies between these two different reporting mechanisms and can downplay the significance of climate-related risk on the company's present and future value. Do you see the convergence in various disclosure initiatives tackling this issue?
I think the convergence is going to be towards including it in financial reporting. I think that in particular investor organizations have identified that the problem with separate disclosures in sustainability is that they're not comparable year over year. And there's no rigor to the methodology. That if they're included in the financial reporting, even if they're in the MD&A or something that looks like an MD&A that is an MD&A for sustainability, that what you've got is officer certification, and then you've got at least the first levels of audit assurance. And I think that's the problem with the volunteer reports. And I do think there is some convergence in that respect.
Thank you. You talk about a lot of climate disclosure requirements. Someone is asking, is ISO 37000 relevant here?
So ISO 37000 is the attempt to create the first global governance standard in terms of trying to, again, bring some consistency globally and to break it down. And so I think it's relevant in the sense that it will help create a common language globally to what effective governance is. One thing we do know is that managing climate-related risks and opportunities, it requires really effective governance, both at the oversight level of the board or the pension board or the corporate board, and then at the managerial, the senior executive, right down through the organization.
The first question, you talk about how can companies prepare with these climate disclosure requirements. So we have a question about if investors engage with their portfolio companies, how can they better support them on climate issues?
So there's a number of things. I think that engagement is really important. It's really a critically important investor tool. And how they can help them is to be, first of all, identifying where they see that there's that governance and oversight is not happening. To maybe point them in the direction of some of the free tools to get them started, and to create an expectation that the next time they're engaging or the next annual report, they expect to see some reporting on this to satisfy them. As we move along this path and as more regulation comes in force in terms of keeping an eye on your value chain, and for financial institutions, of course, for your financed emissions, then the expectation for the portfolio companies or the companies to which financial institutions are lending or in which they're investing is going to become higher. So everything to do to get them started on that path. And we forget, because we see so many media accounts now of companies that are well on their way. But we have hundreds of thousands of companies in this country, and even if you take out the mom and pop kinds of businesses, there are, literally thousands of companies of which it's either not yet on their radar or they're terrified to think about starting. So to support companies to get somebody in the boardroom or to go as an investor with someone from CEC or CCLI to just start that conversation, do the basic education and say, you don't need to have at this point until the regulation's in place a comprehensive thing, but you should prepare for it. So you should start tracking your admissions where you can, or identifying why you can't if you can't, set some goals so that you can start to tell investors that invest in you, where your benchmarks are. Because the whole idea is to ensure for the company, the portfolio companies, to ensure that that capital flow stays, right? So it's in their interest to do this. It's in investors' interest, but it's very much in the company's interest.
Yes, I think there are so many different companies at different stage in their climate governance journey, and the main point is really to start this process. We have another question that says, could you provide an example of an opportunity for public-private partnership related to the Canadian Net Zero Emission Accountability Act? How can investors take advantage of this act?
So I don't have one at my fingertips, and I apologize for that. But I do know there's a lot of information on the website for the act, and a lot of sort of calls for information that are out there now. And this, it's relatively new in the sense of the first announcement about carbon reduction have just been happening. But I think it's I would say it's a pretty user-friendly website. And so I definitely commend it to it. I think the interesting thing for me, when I meet companies that are well on their path, and they might be mid-cap companies, for example, and they actually they have someone who just as a side thing, just does some tracking of those sites to see what the calls for proposals are. But I'd very much say the same thing about the Canada Infrastructure Bank as well, right? It's got opportunities, and it's a question of trying to track it a bit so you can see what might be there for partnership. I don't think it's particularly difficult, but I would agree that it's not something that comes to your attention unless you go sleuthing a little bit for it.
Great, thank you, Janice. We don't have any other question, unless we have no other question. Oh, really helpful, thank you. So I just want to mention that we will share the slide with everyone that attended the webinar, and the webinar will be on our YouTube channel. Thank you, Janice, again for your time. Maybe I'd like to invite back Omar if you want to say a few words about what any updates about CC.
Yes, thank you. Thank you so much for this presentation. Really helpful. When we were preparing a webinar that we did for participants last year, this was an aspect of the content that we knew was really important to include for CEC participants, and we ran out of time of that opportunity. So really grateful for your work to help share this information with us today. And as it's really valuable. Selfishly, I really needed to know more about this, so really appreciate your help with that. And in terms of what's coming for CEC, I'll talk about two areas of our work where we're focusing a lot of our attention and our efforts right now, which are around the engagement, the direct dialogue that we're having with companies and with research. And as one of the questions was raised earlier around what can we do to advance these engagement efforts. So right now, CEC has launched 32 dialogues with some of the largest GHG emitters in Canada that are listed in the Toronto Stock Exchange. And we are recruiting additional institutional investors to launch the remaining teams. I mentioned that we have 40 companies in the focus list, and up to now we have approximately 36 investors that are able to join in this collaborative efforts. So if you're interested in in having more information about participating in CEC, please get in touch with us. I would love to speak with you. And then also our efforts are focused on putting together a benchmark, which was also raised around what can we do as investors and other actors as well to help raise the importance of these issues, help educate companies and their boards around how are they performing and a variety of indicators. So CEC is putting together a net zero company benchmark that will track the progress that companies are making on their net zero journey, and issues that will be assessed. This, just to say, this benchmark is also inspired in the Climate Action 100 Plus benchmark methodology. So we're replicating that benchmark. We do have a technical committee that advises on the development of the benchmark. It will assess things like companies' commitments to achieve net zero by 2050 or sooner, depending on the sector that the company is in. For example, utilities companies are expected to transition sooner. Other aspects that the benchmark will assess are the strategies and the targets that companies set in place to achieve that GHG neutrality. And very importantly, our technical committee created a working group that created a set of indicators and metrics to assess companies' efforts regarding the just transition. And in the Canadian context, the degree to which those transition issues may have distinct impacts on Indigenous communities in Canada. So also talking about the convergence of these efforts and standards that are international. We're collaborating with our colleagues that are part of the Climate Action 100 Plus benchmark to ensure that our benchmarks are aligned, and also with other organizations like the Benchmarking Alliance to ensure that their just transition benchmark assessments are also in alignment with the kind of efforts that we're providing to create clarity around just transition issues and the performance of companies on these issues. And those are really the big next steps that we have in our program. And we invite you to visit our website. We invite you to, whether you're an institutional investor or not, you can sign up for announcements that will be made in the future years. And yeah, and just to keep in touch about the efforts that we're doing. It feels like it's been a year already, but there's still so much growth that we're having, and so much development for what is a complex issue like climate change. Sonia, you're muted.
I'm on mute, apologies. Thank you so much, Omar, and thank you again to CC for inviting us to organize this great webinar. Thank you, Janis, for sharing your insight. As Omar said, you can visit CC and CCLI website to know more about what we're up to. And I wish you a great afternoon. Bye-bye.
Thank you. Have a good day.